Waiver of rights. I'll be discussing Article 6 of the Civil Code. Let's start with the basics. What is a right? A right is a legally enforceable claim that allows a person to require another to do or not to do a specific act. Rights come in different kinds. First, we have natural rights, which arise from human nature itself, such as the right to life, liberty, privacy, and reputation. Second, political rights, which allow citizens to participate in government, like the right to vote, to hold public office, and to petition. Third, civil rights, which belong to a person by virtue of citizenship, such as property rights, the freedom to contract, and equal protection of the laws. Civil rights can further be classified into real rights, which are enforceable against the whole world, and personal rights, which are enforceable only against a specific person. Now, under Article 6, the general rule is that rights may be waived. This means that a person may voluntarily give up a right that exists in his or her favor. However, a waiver is only valid if three requisites are present. 1. There must be an existing right. 2. The person waiving must have knowledge of that right. And 3. There must be a clear intention to relinquish it. But like all rules, there are exceptions. A waiver is not valid when it is contrary to law, public order, public policy, morals, or good customs. For example, waiving future inheritance, political rights, or future support. Or it is prejudicial to a third person whose rights are recognized by law. To put it simply, you may waive what is yours, but you cannot waive what affects others or what the law forbids you to give up. To summarize, rights may be waived if the waiver is voluntary, informed, and lawful. But a waiver is void if it violates public interest or prejudices others. In the end, the concept of waiver balances individual freedom with social responsibility, reminding us that while rights are personal, they exist within the limits of law and justice.